on my screen here. So I will from time to time be looking on my left-hand side as I've got another screen here. But so long as you can see what I'm seeing, which is an introduction to holistic family mediation with Sushma Kotecha. Okay. So a bit about my background. As has just been presented, I used to be a practicing lawyer for 27 years. I'm also divorcing myself, so I guess you can call me a divorce expert. I come from a place of genuinely understanding and knowing what you guys are going through and other people who are facing divorce and family breakup. And of course, I bring a whole host of professional experience, having represented God knows how many thousands of clients throughout my 27-year career in family law. I qualified as a mediator back in March 2010, gained accredited status. We were just talking about accredited status earlier, and that's the gold badge of honour, which means that I'm actually able to sign off what is known as MyAM certificates. There is a prerequisite before you go to court, unless you're exempt, that you come and see a mediator for an initial assessment meeting. And it has to be an accredited mediator to get the signature on there to allow you then to go through to court application if mediation is not considered suitable, or if one or the other party doesn't want to mediate because it's totally voluntary. So, you know, that's a huge sort of bonus and benefit for me in the state that I assume that most people want to come to an accredited mediator. I've worked at various firms in the East Midlands. My first 20 odd years, I practiced in Leicester at small firms and organisations. But the latter part of my career was based in Nottingham, where I landed a job at Shoesmiths. And then my last position was heading up Stowe Family Law's family team. And as I've just said, I made this life-changing decision during lockdown, March 20. Well, actually, it was last year when I decided, but we went into lockdown March 2020. And it was the year after that I decided that, you know what, I need to give up my legal hat and follow what I believe to be my calling, my passion, which is dispute resolution and helping couples resolve their conflict, in my view, in the least self-destructive way possible, around a virtual mediation table with myself, and I then launched Holistic Family Mediation. So what I'm now going to do is take you through just to my website, because I think that'll be helpful, and I'm hoping that you're going to see that. And I'm going to turn here because I then see it on this screen. Can you all see my website? Is that visible?
I can.
Brilliant. I'm assuming that the rest of the members can as well. So I just want to sort of help you navigate this, because if you ever decide to mediate, or there's referrals made for mediation, this is an online service, it's a virtual service, it's a labour of love, and I've spent a lot of time in making sure there's useful information for participants who may use the service, who may not. So even if you're not using it, I think those of you who are going through divorce and separation, and perhaps mediation isn't suitable, or you're far, you know, beyond from being a case that can be suitable for mediation, you'll be able to find resources here that can help you. So the first section, of course, is about me, a bit of an introduction in relation to myself, and testimonials, which I think are always helpful to give you credit and kudos. And then the services page, which is important because this is where people will purchase online the services that I offer. And of course, for mediation, you've got to have an initial separate meeting. My meetings are always separate with the parties to assess suitability and to give information and guidance on what mediation entails and what it's about. And they are charged out at a fixed fee of £125. And you can see here that people can book. And this, if you book now, it takes you straight into my calendar, and they can book and pay online. The most, I think, beneficial item here is the free 15-minute discovery call. So where people are in doubt, they've made, you know, they've visited my website, you know, read the information, the lawyer perhaps has referred them to me, but if there's still doubt, they're able to call me. But I make it very clear that I don't give legal advice. As a mediator, it's not about giving any legal advice, it's about being impartial, third-party neutral. But I'm able to, of course, give pragmatic guidance and information to help parties reach their own resolutions. And then, you know, if you go through this, if it is a mediated case, then they're going ahead and they're purchasing the sessions as we go along, because it's a pay-as-you-go service. There are referral forms, of course, that parties will need to complete, and I'll touch on that a bit later on. But if it's a lawyer referral, they'll complete the form for you. Quite often, the lawyers will just say, go on to Sushma's website and do the self-referral. So they're very straightforward. And in fact, if I click onto the self-referral form now, you know, you're literally putting in your details, the other party's details, and it's just a checkbox about your marital status. Is it all issues, child only, finances only? And if there are any other additional concerns, if there's lawyers engaged, you'll give me those details I need to submit. So fairly straightforward. But if there's anybody's tech phobic, who doesn't like electronics, who doesn't like to be working in the virtual world, we're not going to be suited. There are obviously other wonderful mediators out there that can actually support and assist in person. So this next page is on mediation. So again, quite a lot of this we covered in today's presentation, so I won't bore you with this particular page here, but it's the frequently asked questions, which I think will be very important, because there's going to be lots of questions. Even after this session, we don't have enough time to go through all of them. But if you look, I've spent, and you can see it's a labour of love, because I've literally gone through, you know, all the questions that prospective clients will have, so that they can literally drill down. And so one of them is, you know, is family mediation confidential? You'd go there and it tells you, you know, yes it is, and goes into more detail. So I think that's helpful to those that might want to use my service. And the resources page, again, very invaluable as far as I'm concerned as a resource. I've spent a lot of time thinking about what would divorcing clients need in terms of resources. So you see, again, we've got drop-down headings: mediation and resources for children and young adults. So if you clicked there, there are various websites and resources, if you then follow through onto, that will lead you onto them. Counselling, coaching, psychotherapy, mental health, wellbeing, holistic therapies. I've spent a lot of time on this so that it can be as resourceful and helpful, not only to my participants, but to anybody like yourselves, just to go on there, have a look at it, and it's going to help you out. Sorting out finances, children arrangements, which are obviously the key contentions when we're looking at divorce and separation. And these are key documents, a package of documents at the appropriate times that clients will receive when they, you know, buy my service. So they're here anyway to look at for free, but, you know, I want the participants to actually prepare for the assessment meeting. So if you were going online, making a referral, and you purchase the initial assessment meeting, you get a package of documents to read and consider so that you are prepared for the meeting. And, you know, there are obviously tips on making sure that mediation is successful, etc. So, you know, I would say that if you're going through divorce or separation, look through these documents. You've got the Parenting Through Separation Guide, Survival Guide for Finances and Divorce. These are all very useful tools which you'll get, you know, the law and guidance on all the different nuances in relation to your case. And finally, a blog page. So, you know, my latest blog, I think, is going to be very helpful to anybody who's actually thinking about proceeding with mediation, how to start mediation and get the ball rolling. So let's come out of here and then take you to the next slide. So why holistic, and what is holistic? So, you know, I made a conscious decision. I wanted to provide a service, in my view, which was not just about the legal rights and responsibilities going through separation. In my view, having faced divorce and family breakup myself, so I've been through the personal journey and I've seen thousands of clients through divorce and separation. I think if you really want to heal and recover and have happier, healthier lives post-separation divorce, you need to actually look at it in a holistic manner and think about your mind, body, spirit and soul. So I will guide participants to actually take, you know, on board all the tools and resources that I provide on my website, and actually, you know, be kind to themselves and help themselves in terms of their emotional and psychological well-being, because if they're not in the right frame of mind, they can't make informed, sensible decisions, you know. So to me, we've got to have a holistic approach to family breakup. It's not just looking at it as an isolated, you know, what are my legal rights and responsibilities? The question was asked by Aruna, you know, what made me give up my legal hat, you know, and I've said it no longer resonated with me being a lawyer. You know, I felt that I was out of kilter. There was a sense of calling that I need to give up that and actually take a leap of faith and follow what I believe in. And, you know, I think for me, COVID, you know, was actually like a silver lining. I know it's been really awful and terrible for many, and there've been losses, etc. But I think that there is actually positives that people have gained from lockdown and having time to actually think and reflect what's important to us and what we want to do on our lives and how we want to serve, you know, people. And in my view, I want to serve people facing family breakup and conflict by giving them a safe space which I can hold to reach their own resolutions. And I tell you why it's so important to me. It's this final point here, you know, where there are children, it's really important to work hard not only on ourselves, to rewire ourselves and to think about the separation in a different manner and not play the blame game, because we want to be able to share space with our kids moving forward. And so if we can have a, you know, constructive divorce, a dignified divorce, which is civil, then we remain civil with our ex and we can share space with them moving forward. So I come from a place of knowing, a place of experience. I practice what I preach. You know, I could have been bitter, twisted about, you know, various things happening in my marriage. And there's never two, there's always two sides to the coin. So, you know, one isn't always right and the other isn't always wrong, no matter what. There's always going to be two sides to a particular scenario. And as a result of the way I dealt with my own divorce, you know, I was able to go to my son's graduation. We divorced, well, we separated in the year of his graduation. So it was fortunate that we were able to go to the graduation together. Yes, the dynamics changed. We stayed in a hotel, but me and my daughter shared a room, and my son and Raj shared a room. 5 years since I've separated now, my daughter is graduating. And in fact, she graduated last year, but as you would know, through lockdown, there was lots of cancellations. So the graduation is now coming up in March, and we're going together to celebrate and to enjoy that. And I don't think that would have been possible had I been bitter, twisted and toxic and not had the heart, the capacity to forgive and to move on and to accept where we are. So I think, to me, that was a big driver. Some interesting facts next before we move on to what is mediation. These are the divorce stats that just came out in 2020. It's suggesting that there actually is a decrease or decline in divorces here. But what I want you to understand, that whilst it's suggesting, you know, for opposite sex couples in 2020, the divorce rate decreased by, you know, 4.8%. In fact, that wasn't the case. In reality, it was just because of lockdown, because there was obviously a backlog in court services. Everyone's life stood still. And I think many couples decided perhaps not to go for the divorce during that period of uncertainty. And also with the new divorce, new no-fault divorce coming into fruition, fingers crossed, in April, there would have been conscious decisions not to file for divorce under the existing law, which is fault-based. So I think that's going to have skewed those figures. But, you know, certainly, sadly, 4 in 10 marriages are coming to an end, and I don't see that ending anytime soon. And we're becoming less tolerable, it seems, because the actual median or average length of a marriage has decreased. It used to be 12.4 years, and it's now 11.9 years. So it looks like we're becoming less and less patient to remain within marriages, or having more courage to leave unhappy marriages, which I would always wave the banner and flag for. And reasonable behaviour was always the most common ground. But as I've said, hopefully, fingers crossed, with the new no-fault divorce coming into fruition, that's going to end the blame game, which in my view should have, you know, been sorted out and, you know, come into fruition many years ago. It's taken near enough 50 years for the old archaic law to be changed, and thankfully it has. The last figure here is not an ONS statistic. It's just my average best guesstimate of what you're spending on legal costs. On average, I expect clients to be spending about 15k each on their legal fees, and that's why, if you can look at dispute resolution options like mediation, it's going to be better for you and your families. So what is mediation? It's not about getting you back together. It's not therapy. You know, it's not going backwards. It's actually a future focused resolution to help you sort out problems with my help and support outside of the courtroom. There is this myth that when people come to mediators, I'm going to help them get back together. So I always make it very clear at assessment meetings, they need to know what my role is. Obviously, if there was any room for reconciliation, or they're under that misconception, I'm going to signpost them off to counsellors and therapists to get them back together. In mediation, we don't only look at the legal issues, so we are able to look at other softer issues and topics like communication difficulties, boundary setting, which I think is beneficial to the parties, because from my experience, often it's those issues that need to be resolved before the parties can be sensible and think about the legal rights and responsibilities. So that's, in my view, another plus point and a bonus, because courts are not going to be bothered about these soft issues, and certainly your lawyers probably not going to be too bothered neither. But to you, the clients, it's very important to have these issues aired and discussed, and hopefully reach some understandings to allow you to move forward. So what are the 4 key principles of family mediation? It's a totally voluntary process. In the UK, you can't mandate mediation. However, there is judicial pressure from the courts, especially with the backlog as a result of the virus. I've had a number of cases where there has been a court application issued for Children Act proceedings, but it's been kicked back, saying to the parties, we think you should go to mediation because it's going to be, you know, several months down the line before you get a hearing date, and there are no significant, you know, welfare issues here. And if there's no safeguarding or welfare issues, the court would want you to take responsibility and make some effort to try and reach your own resolutions. There is, however, an expectation to attend an better known as a MIAM, you might have heard the term, before you actually embark upon a court application unless you're exempt. So that's the only requirement under the UK law at the moment, and it's for the applicant to attend unless they're exempt. There is no requirement on the other party, the second party. I make an invitation for them to attend, but if they choose to bury their head in the sand or they can't be bothered, then, you know, mediation isn't going to go any further forward. So it's a confidential and legally privileged process, which means the parties are able to talk about various options and solutions without feeling that they're going to be held bound by that proposal or held to ransom. So again, I make this clear in my assessment meetings with them that, you know, this is going to allow you the opportunity, a safe space to just tentatively put proposals forward. You don't have to be fearful that you're going to be bound by it. Let's explore, let's think outside the box. When you're dealing with financial mediation, that is the only part which is open, and hopefully you understand what I mean by open meaning that it's not confidential, it's not privileged, it can be used in your litigation proceedings if mediation fails afterwards. So disclosure has to be undertaken on a full and frank open basis, even within the mediation process. The decision making rests solely with the participants. So I want people to be very clear that I don't sit there as judge and jury. I'm not going to make a decision for them. They have to do the hard work. There has to be this capacity to hear one another and to think about compromise. If it's my way or no way, it's never going to work, because I can't be judge or arbitrator. If that's what they need, they've got to go to that forum and not come to mediation. Finally, it's managed by me, third party neutral. So if there was a hint that I had any kind of, you know, engagement with one of the parties in the sense that I was, you know, involved in perhaps giving them legal advice or personally, you know, knew them, obviously I would not mediate because I need to be completely third party neutral for this to work. What are the key benefits of mediation? Well, you know, let's face it, it's going to be damn sight cheaper than going to court and litigation. It's quicker. You know, there's a huge backlog in courts. Even when there wasn't lockdown and COVID, we were still having delays, we're still having cancellations. It's exacerbated now. You remain in control. You know, I always say to parties, surely you want to make the decisions for your children, you know, and about your finances, or do you really want to give that decision-making power over to a judge, you know, a bench of magistrates? I know that, you know, I'd probably say 25% of cases may need to be in that forum because of the complexities of their case and various other ingredients that might be engaged in that case, but 70 to 75% should be sorted out outside a court. It's a kinder, you know, compassionate, dignified way of resolving disputes. And as I said, you know, one of my key motivators in setting up this service is that you can share space, you know, with your children, and the children will really value and appreciate mum and dad taking responsibility, you know, setting their egos aside, you know, because that doesn't help anybody, and actually working through this, you know, in a dignified way to be future focused to sort of reach their own resolutions, which then would mean that when there are, you know, key events, graduations, birthdays, marriages, you know, births of grandchildren, you can actually share space with your ex. And I think that's a huge benefit for everybody. Next, how to make a mediation referral and the costs. Well, I'm going to suggest that you read that blog that I referred to on my website. I'm not going to click onto it now, but, you know, if anybody is actually thinking about it, read that, because it's going to make it very clear. In a nutshell, as I've said, you complete the self-referral form, you pay for the MIAM. That would then generate a package of documents that you would receive to read and consider. I would then invite your ex-partner to also book an assessment meeting with me. However, you do have the option of saying to me once you've booked, because you can reply to the acknowledgement email to say, don't send out an invite to my ex just yet, because I want to have my meeting with you first. Because there are some cases, actually, the lawyer has just said, go and get yourself a MIAM certificate because, you know, this needs to be in court. Now, if they've got no intention of mediating, it's no point me sending an offer letter to the other party to come in and have an assessment meeting. So, you know, it's made very clear when they purchase that assessment meeting, their automated email says, if you don't want me to write to your ex, please confirm, and I won't. So there's no obligation for me to write to your ex. We've discussed it's a fixed fee of £125 and there's no VAT, and it includes me sending those MIAM certificates to you or your lawyers. The mediation sessions, if it's suitable and both parties are willing, they're then charged out at a fixed fee of £187.50 each for a 90-minute session, and that's based on my hourly rate of £250, which is shared between the parties. Sometimes, of course, one party may offer to pay for the mediation costs, and that's entirely up to them as to how they decide to proceed with that. Now, I mentioned exemptions, so I've listed here some exemptions. It's not not an exhaustive list, but it goes without saying, if you've already reached an agreement, of course you don't have to come to mediation. You can bypass that because you've agreed and you're filing a consent order application. If you're already in court proceedings, clearly mediation isn't going to be suitable, so you can tick the exemption box. If there's evidence of domestic abuse, financial abuse, violence, again, there you can tick the box and you attach the evidence to be exempt from attending a MIAM with me. Urgent applications, that need to be sorted out without notice to the other party, like if you're fearful that your child's going to be abducted, obviously it's a no-brainer. Mediation isn't going to work. So, please do have a look at that. And I've put you a link here to the government guides on those exemptions. So I'm going to share these slides with you, and I'm not going taking you through each of the links at this stage because we'll be here forever. But I just think it's helpful that if you do spend some time afterwards going through this, if you click on the links, I think they'll be helpful and give you more information. So what to expect at the initial separate assessment meeting, the MIAM. There is going to be, as I said, a package of documents generated for you to read in advance to prepare for the assessment meeting, and there will be a form, an initial mediation information form that I would want you to complete and send to me. So I have a bit about your background, so I can get a feel for your story and what's important to you. Also, I will deal with the core principles of mediation in more detail and go into how mediation works in practice, so the parties and the participants know what this means to them moving forward. How is this all going to actually work out in practice? I explore other dispute resolution options with the parties as well, because mediation isn't always going to be the best option. So you would then have the right to make an informed decision, what's going to work for me. I refer to the agreement to mediate contract because parties are going to have to sign up to this contract if they are going to mediate. And so I want them to be clear on the principles and the rules and regulations. Remote mediation, of course, would have additional rules in terms of making sure that you're alone in your room. It's not recorded, it's confidential. And people say, well, how do you police that? Well, I can't. So a degree of this is going to be based on trust and faith on the participants. And if there is no trust and faith, clearly this isn't going to be the right forum for you. The main part of the meeting, I would say, is my risk assessment, and I ask a series of questions to sort of understand where they are in the grief cycle, to see if they're actually ready mentally for mediating, if there are any concerns, big red flags, which makes me think this is not going to be suitable for mediation. So when might a case not be suitable for mediation? So you must be thinking there, what do you mean? So what I mean there is that, if there are grave safety concerns or welfare issues, safeguarding issues raised by one or both the parties, about the parent's capacity to provide an adequate level of care for their children. Obviously, I can't investigate as a mediator. So if there are those red flags and it needs to be investigated, it's going to have to be a court application. If there's allegations of drug, alcohol consumption or mental health, which it goes to the heart of their capacity to mediate, I need to think about that. Is this going to be suitable for mediation? And sometimes when I meet with participants, it's plainly obvious to me that they're not ready or they've not got the capacity. And so with the best in the world, it may seem that mediation is a perfect solution because it's cheap and it's quick. But if they haven't got the not got the capacity to mediate, then it's not going to be the right route for them or their family. We talked about domestic abuse. That is an exemption, but sometimes, people don't recognise it's an exemption. So when they come to the assessment meeting, if I'm alerted to coercive, abusive control or abuse, which I think, it plays a huge part or, pattern in the marriage, and it's not just a one-off as a result of the major breakup, I need to think, is this a case which can be safely mediated? Deep-rooted, trust issues. When parties come to me and they just don't trust the party and there's lots of questions and they need like a forensic of the finances, this isn't going to be the right forum because I don't do a forensic. I have to accept at face value the disclosure that you've given is honest and frank. And if there is grave concerns about gaping holes or, he's funded, he or she is transferred assets to X, Y, and Z country, I can't investigate that for you in this forum. So, clearly that's going to start saying to me it's not going to be suitable for mediation. So the grief cycle is important. I'm going to come on to that in a moment. I don't know if you've heard of the grief cycle, so let's just go on to that. Has anybody heard of the grief cycle before? So this is effectively a cycle which was based on bereavement, and in my view, going through divorce and separation is a living bereavement, and we all go through this, right? If you spend a bit of time looking at this graph, we would all have been through this, the denial, the anger. That is always there at the beginning, and that's not a time to actually think straight or give instructions or actually participate in this kind of forum. What you want to do is obviously at that stage is gather information, you know, and to sort of gather your thoughts and take some time out for self-care, for self-healing. You know, we need a lot of emotional support. You know, you're getting down here and you're trying to sort of bargain and you're struggling to make sense of what's happened, you know, because it's literally floored you. You weren't expecting it. Or you might be with a party that actually had already come to terms that the marriage is ending. And so, you know, quite often people are at different ends of the cycle because, you know, from my experience, quite often one party's ahead and they're already, you know, come to terms that marriage is broken down and they've kind of got through the depression stage and they've gone to the acceptance stage. So I need to make sure when people are coming to mediation, they're actually near this stage, because that's when they can make informed decisions and have a clear, you know, headspace to kind of broker their own settlements and decisions. Hopefully that makes sense. So on the basis that mediation is suitable, both parties are willing to mediate, you know, what happens in actual mediation sessions? So this slide is about what do I do to help the parties in mediation. And so you'll see there's a whole host of things here. I mean, effectively, you know, I'm holding a safe space so that the parties can be heard and understood. You know, I'm helping them define their issues, so we're agenda setting at the outset. There is like a psychological strategy. Also in mediation, what we do is we help them find common ground. And often when it's children, I virtually bring the children into the room, as in virtually, by talking about them. I'm asking the parents to give me descriptions of their children, you know, describe them in 3 words, just to know their characteristics. So we actually are centering on their needs, and that really focuses them. And quite often the common denominator is that we want to work together to have a limited impact on our children's emotional, psychological well-being. And you know, when you find common ground, you find that the parties then start working together because they need to make it work for the sake of their kids. So we're clarifying, you know, areas of disagreement. What are the key issues that should be explored in mediation? What's actually going to serve them? It's future focused. If there are issues about the past and what happened historically, I'm going to say that's deep-rooted issues that are obviously affecting your capacity to be sensible and think reasonably in this process. And maybe you need to think about some therapy, you know, whether it's separately or together. And, you know, quite often parties are working with therapists alongside, you know, mediating, and that works really well. We also explore the need for other experts. You'd appreciate where you've got, you know, pensions, properties, businesses, you know, do we need to hire experts to evaluate for us? That's a necessary exercise, and I go through how I can support them in getting the experts reports in place. If they've got lawyers, the lawyers will do the drafting of the letters. If there's no lawyers, whilst I can't draft the letters for them, because as I said, I'm no longer a lawyer and this is my mediation role, I can guide and support them in how to do that themselves. We explore options, you know, what are the solutions, thinking outside the box. So we're kind of going through this exercise as to what is it that you want to propose, what does he want to propose? And then, you know, my role, as I've said, is not to give legal advice, but I can give my pragmatic guidance and information on the law applicable and what a court, you know, may or may not endorse. So sometimes, you know, people in the mediation will say to me, you know, is this fair? Is the judge likely to endorse this? And I'm able to say from my experience, you know, this is within the remit of the discretion, or actually it's highly unlikely. And then that kind of gets the parties to kind of think, you know, in a way where they can reach a compromise which is likely to be endorsed by a court. Evaluation is important. So it's no good making a proposal that you then can't follow through on. So we look at the capacity for people to follow through on their proposals and the net impact on them and their children. So we need to understand, if you did reach a resolution in relation to the children's arrangements, what does it mean to the kids? What does it mean to the parents? And the finances? Okay, so you've tentatively reached an agreement on capital division, on pensions, on maintenance. Let's see how it looks if you were to implement it. So that's really important, the important exercise that we do in mediation. And the key thing is I'm supporting them to communicate. You know, you would know a marriage breaks down because we can't communicate anymore. You know, we're seeing red, we're not seeing eye to eye, and I've got to be their eyes and ears. And quite often I'm reframing and summarizing and actually making sure that they are being understood and heard, because that's a key part of the process to get the parties to come to some form of compromise and resolution. So what else do mediators do? If indeed they reach agreements, then you may have heard of open financial summaries and memorandum of understandings. These are key documents that mediators can prepare, which will allow the lawyers to utilise to convert into legally binding orders. I'll be honest, of late, not many clients have asked for these documents to be prepared because the lawyers are quite happy just to use my interim summaries if indeed there are agreements to, you know, convert into legally binding orders, because these come at an additional cost. There's child arrangements that have been agreed, and in that instance I may be asked to help them prepare a parenting plan, but really what I do is I encourage them to draft their own. So on my resources page there's a link to CAFCAS's, you know, parenting plan template, and it's not about me making any extra money or income out of this service. So really I'm encouraging them to do as much as they can and only utilize my service if they need to have that extra service from me. It's the cost of preparing these additional documents. You'll see there, if the net assets are below 1 million, then to prepare the open financial summary and the memorandum of understanding, there's a fixed fee of £250 each. If those net assets are between 1 million to 2 million, then it goes up to £400 each. That's because there is more assets and complexity in the documents that I prepare. And then if it's above the threshold of 2 million, then I need to look at how much time I'm going to spend these documents, and we agree a fixed fee. Parenting plans are fairly straightforward. There's a fixed fee of 150 each for that. But like I said, these documents, you know, the last time I prepared these would have been, I'd say, probably 2 or 3 years ago, because they're kind of outdated. This is what we were trained to do, but you know, people are becoming savvy and recognizing, well, if you're preparing outcome summaries, which is what I do, and they're useful and they're concise, then the lawyers can use them. So, you know, in between sessions, it's quite often required and helpful for me to prepare these summaries. They come at a cost, but again, they're charged in accordance with hourly rate and shared between the parties, and it's a damn sight cheaper than both the parties having lawyers and litigating, you know, and going through, you know, being charged for each telephone call, each letter. So of course my service isn't charging for the minutiae items, but the substantive summaries, of course, there would be an additional cost. And beyond that, of course, if we're doing financial mediation, if we're doing the Form E exchange within mediation, I would then have to consider the Form Es and draft a spreadsheet, their schedule of assets, income and liabilities. And that piece of work could take me anything from an hour to 3 or 4 hours, depending on the complexity. The parties are then going to, of course, commit to purchasing that additional service, because that's going to be helpful to them in mediation, because they can see in black and white what is it that we've got to share here. And it'll be a working document that we can then edit as we go through moving forwards. So what's my vision and mission? I suppose you probably guessed what it is. You know, really my vision and mission is to inspire and empower separating couples to take stock and make their own informed decisions, to avoid court at all cost, unless of course it's not safe and suitable, in which case you've got to go down the court route. I want to have a positive impact not only on the separating couple, their children, but also on future generations, because I truly believe that if you can deal with divorce and separation in this kind of forum, then we're going to have less dysfunctional families moving forwards. Also, part of that, of course, is helping the participants to have a happier, healthier lives, you know, post-separation divorce. You know, I'm kind of living in utopia world, hoping that we're going to have, you know, harmonious blended families, and that's what I'm aspiring to, ideally. Finally, to flip the script on divorce, it doesn't have to be so bitter, twisted and toxic. You know, we all have a choice. We all have a choice. How are we going to deal with the challenges we face? You know, are we going to go this route, or are we going to go this route? Are we going to swallow our pride and let our, you know, ego be lifted for a while? We have to work hard on ourselves to sort of work through this, in my view, in a dignified way. I'm not saying that it's going to be, you know, compatible in every scenario. As I've said, 20–25% of cases, you know, may need to go down a different, more directive route, like the court or arbitration, but certainly, you know, 70%, 70 plus cases, percent cases should go through this particular resort, so that they can share space together with their children moving forwards. And if there are no children, you know, I think if you use mediation, then you can probably move on and have a healthier, happier life. If you're still holding on to the past and not forgiving and letting go, and you've had a toxic battle in court, you're still stuck in the past. So it's just about, you know, freeing ourselves, I guess. So that's me.